Resolved, the Division Court Department, hear ye, all persons having business to do before this court will draw near to their attendance and shall be heard.
All right, please be seated. The first case for oral argument this morning is Nicholas Vassanelli versus City of Syracuse. And just so you are aware, both Judge Sentra and Judge Kearney are recused on this.
Thank you, Your Honor. May it please the Court, I understand from my opposing counsel's communication that they are contesting this matter is now moot because Justice Gilbert has granted summary judgment on their motion. We contend that it is not, both because there is a novel issue of law and that this is capable of repetition yet evading review. We submitted a proposed order on the preliminary injunction on April 8th of 2016. There was a hearing on April 13th of 2016, at which time Judge Greenwood issued an order in invoking the preliminary injunction and the temporary restraining order. The bond, the undertaking, which was proposed at $100,000 and granted by Judge Greenwood, was opposed.
Just so you know, we know all those facts.
Okay. Well, I would say that in light of the decision by the lower court at this point, that the TRO and whether or not that TRO was violated by the City of Syracuse is an issue separate and apart from the merits. There was an application by order to show cause for contempt based upon their failure to comply with the TRO.
Do I have this right, just so if I got it in my head, that you take issue with the fact that the temporary order will continue until the preliminary injunction takes effect? So throughout this period, if I understand your argument correctly, that direction to continue paying at all times remained in effect, and that's what the contempt should be based on, correct?
Correct. The October 7th order vacated the TRO, and so that was in effect from the date of the preliminary injunction hearing, or the order to show cause, rather, until October.
So we have to decide whether or
2016.
not that's a lawful mandate with which the city had to comply.
Correct.
Okay.
Additionally, the other issue is that the court did not address the application for fees based upon the temporary restraining order and the preliminary injunction. And with respect to the public interest component, you know, as we quoted in our brief, Judge McAvoy has found that when someone is entitled to benefits, that affects the public interest. And the Americans with Disabilities Act and the Rehabilitation Act, which is at issue here, affects that public interest. Judge Gilbert erred in concluding that no mandate existed upon which contempt could be based. And even though you can't at this point, because of the summary judgment, reinstate the preliminary injunction, the recognition that that order was not properly followed and that there was no hearing on the issue of fees or the contempt could be reversed and ordered to be considered by the lower court. If the court has no further...
So what mandate are you saying was unambiguous?
The
Continue doing something that the city was not doing?
The temporary restraining order required them to pay and provide services which they had undertaken in the past at Mr.
But he'd never had those services, I believe.
He has had services as implemented by the City of Syracuse since 2009. They took away his private nurses and put an agency in place. Then when his needs increased, according to his doctor and the agency itself, they said he needs 24/7 nursing care. The city balked. The agency said, we're not going to continue to do this with home health aides or in the absence of nursing care because we can't.
But then how can the mandate say continues providing X when you have never provided X?
Because Dignity was providing nursing services without compensation. If you look in the record, the testimony of Mr. Penoyer indicates that they were sending nurses in that they were not being reimbursed for because those were the needs of the patient and they met those needs. So when they said, if you don't give us our nursing rate, we're going to back out by March 20th, the city said, well, we're not going to pay you for the nursing rate. And so that's how that arose.
Thank you.
Thank you, Your Honor.
Well, thank you, John. 319, People v. Rogers. Good morning, Counsel.
Good morning, Your Honor. May it please the court.
Mr. Saranda?
Yes, Your Honor.
Good morning, sir.
Good morning.
I find this transcription thing fascinating, just so you know.
Judge, as Forrest Gump said, it's like a box of chocolates. There's a case next term that's coming back because you remitted it for a reconstruction hearing that has two transcripts. Two different people transcribed it. One transcribed it for the DA, one transcribed it for the court. Two different transcripts. So it's beauty's in the eyes of the beholder, because with this system, you don't know what you're going to get.
Well, okay, let's get to the issue then, okay? We have a situation where we have, there's no dispute, there's some inaudible information on it. And so I guess there's two questions that it really boils down to, is whether or not those times that they're inaudible and what stage they were in, were they mandated to be trained by a stenographer? And then the other question I think I have is dealing with whether or not there's any prejudice pursuant to the Harrison case.
The first response, Judge, would be that, as the DA says, if there's transcript, if there's a trial testimony, if there's testimony, it should be transcribed. They say that. There was a hearing here, Map Hunt, that was not transcribed, okay? There was various audible portions, inaudible portions in there. I go back to the absolute that it's a court of record, a steno is necessary at all times. And the analogy I would use is People versus Smith from the Court of Appeals, where OCA had put in this justification in justice court saying that you can record the proceedings. And the Court of Appeals said recorded proceedings are not the functional equivalent of a stenographer. So the whole proceedings there are improper and should not be allowed.
Mr. Saranda, though?
Yes.
Sorry again, sir, but I think I understood Justice Center to be going is, if we get to the end of the analysis, and in terms of prejudice, what I'm struggling with in all candor is whether or not you can show prejudice on this record. This may not be the right case to make this point. Do you agree?
This is a more difficult case than the last time where you sent it back for a hearing. However, I don't know if, based on what the Court of Appeals said in Smith, if you can even get to the prejudicial analysis.
But that's dicta in Smith, I would submit. Maybe you could disagree with that, but that's how it looked to me. But getting back to the point, is a map hearing a proceeding that's being heard? You would say yes.
Yes, and it's a transcription, a court reporter is necessary at there.
So let's go down that path. Do you want the Fourth Department to tell OCA that for every map hearing or other pretrial hearing, you got to have a stenographer in every county in the state?
Yes. Or say no and give me leave to the Court of Appeals.
What about the restitution argument, just to shift gears real quick?
The restitution argument, there was no mention at the time the defendant pled guilty that it would be a condition of his plea of guilty. They discussed it before, an amount of $8,286 numerous times before, but every time they discussed it, the defendant turned down that plea bargain. And somehow it became $12,723 at the time of sentencing. And since there was no mention at the time of the plea, it's our position that he should be given the opportunity to replead or
It's illegally imposed, and therefore you don't need to preserve it.
Yes. Other than that, we'll rely on our brief.
Thank you, Counsel.
Thank you.
Morning, Your Honors. May it please the Court, Amy Hollenbeck on behalf of the people. Just to clarify on the first issue, I don't think I conceded that 295 applies to testimony. If I did, I didn't intend to. But my position, or our position, is that 295 applies to trials. And there was no trial in this case, and in fact, the guilty plea was transcribed by a stenographer who was present.
What is a proceeding that's heard?
I take proceeding as heard to mean trial, because the word trial or proceeding heard, I think the word trial precedes
It says
that in the
tried or
statute.
heard, and I think
Right.
the question becomes that why do you need to put heard in if you say tried?
There are a lot of cases, I've cited a number of cases, both in the civil and a little bit in the criminal, that indicate that if we're talking about pretrial proceedings or pleas, we're not talking about 295, and I think it was mostly civil.
Well, can't you imagine a situation, a case where there might be prejudice, not so sure that that's here?
Right.
Well, let's assume defense counsel writes down a beautiful answer to a question from a police officer,
Right,
and it ain't in there.
right.
That's prejudice, right?
That could be, yes. I mean, I think that potential, it definitely exists, but there are remedies to deal with that, one of the remedies being reconstruction. I mean,
How do you preserve it?
How do you preserve what? I'm sorry, I don't understand.
How do you preserve the issue of it not being recorded?
Even if you don't preserve the issue, even if you don't make the argument until now, one of the remedies is reconstruction.
Is that because it's a mode of proceedings error?
I don't know that it is a mode of
It's not
proceedings
brief,
error.
it's just curiosity.
Right.
Forgive me for getting off the briefs,
Right.
but
If 295 doesn't apply, I don't see how it's a mode of proceedings error. The first issue is the people don't determine whether or not something is recorded. As the court has indicated, it's the office.
no question. Your point really here is no prejudice, right?
2 point, yes. 295 in our position doesn't apply. But number two is in this particular instance, there's no prejudice. The transcript of the map hearing is very complete. There are inaudible words here and there, but it's very, very complete. There's no difficulty in determining what the issues were, what the testimony was. And even if there were an issue presented, it could clearly go back for reconstruction because the whole hearing is there. There are only missing words in spots. So
Now, what about the restitution issue?
on the restitution issue, Your Honor, our position, I don't think we differ on the facts at all. I think the facts that Mr. Sarando has cited, we would be in agreement with. It's just preservation.
At a certain amount, then it's never mentioned at plea.
Not a word that I could see in the plea colloquy.
And
I
then
don't dispute
suddenly,
that.
at sentencing, it's a higher amount than was
Right.
discussed beforehand.
It is based in and the amount that the court ordered is the amount that was in the pre-sentence report. There's nothing raised by defense counsel about, well, how come it went up $4,000 and change?
Well, your argument is not preserved.
Correct, Your
But
Honor.
once again, his position is if it was never mentioned at the time of plea, and then he gets hit with it at sentencing, is that an illegal sentence?
Right, and our position is that it's not preserved and that there's no need for any remedy here, but if the court feels there is a remedy, the remedy would be remand for restitution hearing.
Thank you very much.
Thank you.
Thank you, Counsel. 321, People v. Edwards.
Morning, Your Honors.
Morning, Counsel.
May it please the Court. Your Honors, I'd like to address the first point in my brief. This deals with the multiplicity and duplicity arguments that we're making here. This, as the Court knows, is a 40-count sex offense indictment. Even in light of the bill of particulars that was filed, we have two, if you will, general umbrella concerns. There's a lack of notice in order to prepare the defense, but also it gives the jury the impression that there were more criminal acts than actually occurred. And just starting with duplicity, if I may, and I'll get real specific.
And you recognize that it needs to be preserved.
I do,
And so
Judge.
does the multiplicity, too.
It's true,
And so
Judge.
you're tying that in really to an ineffective assistance.
I am also, Your Honor, and I guess under the umbrella
Interest of justice.
interest of justice as well, because we use that phrase a lot, but what makes something more valid for interest of justice? If counsel maybe should have jumped and done something, that might trigger your jurisdiction as well. If you look at counts 5 through 11, those are the rape counts. And if we can bundle together just for a second counts 22 through 33, those are the Criminal Sex Act counts. The Bill of Particulars gives the same description for all these counts various times during the day and night for single counts. That has to be duplicitous.
Well, here's the problem I have there, is that the court did a nice job at the end, at least my view, of getting rid of some of them that weren't testified to, okay? That was number one.
Yes.
Number two is we have a young woman here, 13, a lady at the time, 13 years old, where there was a number of sexual acts taking place during a period of July 4th to the end of August, and she indicates where they took place, on the couch or in the bedroom. And your argument is the fact that she doesn't say, well, this third time it happened, it was at night, or it was at late July, or whatever, and the time frame from July 4th to the end of August is too, without any time specifications, it's too broad, and therefore, you know, that's where I think you're running into a duplicity argument.
Right, and as the Court of Appeals has recognized, you can have an indictment that perhaps is too vague or maybe has problems, but it can turn into being duplicitous through a bill of particulars, and that, I think you've summed up that part of it. But the multiplicity is also a problem. It's kind of it's a terrible combination of problems here. The multiplicity just has to do with the criminal sex acts. 23 through 27 are the acts that are performed towards her, and then 28 through 33 are towards appellant. When she testifies, and it's on pages 224 and 225, she starts off by saying there were 13 times that I performed these acts on him. Then the prosecutor kind of tries to rein her in a little bit towards the next page, and she kind of comes back to there was really 6 or 7 acts that occurred. And that's what multiplicity is. I mean, that's really what it is. I'm sorry, Judge. I
know, Counselor, but it's fair to say, though, the indictment did charge that many. Okay, it's just that at the end of the day, was not uncommon, the court pares it down as to on whether or not there's sufficient proof to, and which ties in the arguments here is, I understand that you're saying that, you know, what she says, her testimony doesn't really clarify or locate it, but the judge gives the defense attorney an opportunity for a clarification, and I read the judge's charge, and it appears that the judge's charge is to the point that do not convict. All of the jurors have to agree on the same conduct to the specific act, not any other. So the judge at the end does give some a charge addressing that.
On the duplicity, but another problem that you face with all these sex crime cases is that where there's smoke, there's fire, and that's what multiplicity really gets into. And what you have are these really 6 uninterrupted courses of conduct with the same complainant, which should be considered the same crime, and that's not addressed in the judge's charge because he leaves those counts standing. He leaves the 12 counts standing, which should have really been 6, which is
but if the way I look at it, if you're successful, counts 1 and counts 21 still survive.
That's true.
And that's
there are counts
great.
that survive.
Okay, which ultimately he received 7 years on those too, which would be concurrent. I recognize
that's true.
He just got 7, whatever. He got all concurrent sentences of 7 years.
That's true. But the idea of the jury actually distinguishing in their minds when you have all this smoke, to think that they're actually parsing it out like that is kind of hard to swallow. So we are asking officially, Judge, counts 5 through 11 and 22 through 33 to be dismissed. Thank you.
Thank you, Counsel. 322 People v. Grant. Morning.
Good morning. May it please the court, Kim Duguay for the Monroe County Public Defender's Office on behalf of Mr. Grant. In this case, there are significant errors at every stage of the trial, from jury selection through sentencing, that really infected the fairness of the trial. Those errors involved defense counsel, who was woefully ineffective, the prosecutor, who engaged in pretty significant misconduct, the judge, who refused to even consider the possibility for prejudice when there were uniformed firefighters in the courtroom, and a jury, almost half of whom were selected because defense counsel did not want to bother questioning another panel of jurors. The advocates, the judge, and the jury form the 4 corners of a fair trial, and while some of the errors alone were severe enough to render the trial unfair, I would submit that it's inescapable that the cumulative effect of these errors denied Mr. Grant his right to a fair trial. So where to begin? There's a lot of brief in this case, I understand that. So I think I'll focus on some of the issues that really really went to the heart of the trial and less on issues that just might make you cringe a little bit. So I'll start with ineffective assistance of counsel. Again, there were errors throughout the process, the most egregious of which probably started when defense counsel tried to barter with the prosecutor regarding the final 5 jurors.
So that could not have been a strategic decision by defense counsel?
I don't see how that could be a strategic decision by defense counsel. I know respondent states that he wanted to seat an alternate, but if you want to seat an alternate, then you actually exercise a peremptory challenge to get the alternate on the jury. Also, an alternate fulfills any spot on a jury, not just the final 5. And also, I would submit that in People versus Nesbitt, the Court of Appeals noted that, you know, in some cases you need a 440 motion to determine what defense counsel's strategy was. But when defense counsel states on the record what his purpose is, then we need to listen to him. And that's what defense counsel did here. He said, I just didn't want to come back for one more pass when the judge told him that this was improper. The judge actually tried to tell him again, but then he interrupted and said, 7 through 12 is fine. And that ended the proceedings. So, you know, Mr. Grant had a right to meaningfully participate in the selection of a jury. And that opportunity was denied to him when defense counsel did that. Second, and this goes into the summation, was the failure to object to highly prejudicial and inflammatory and irrelevant testimony that came out during the prosecution's direct case. First, on the harm, there's no injury alleged in any of the charges, and yet harm was elicited regarding Ms. Rodriguez and her children's fear that a bad man would come find them and burn their house down.
Here's, I think, and you did clarify when we started. I think the strongest argument you have is, and I do agree, the strongest argument, if I agree with it, is the cumulative errors. And you name it, you go through probably 6, 7, or 8 of them under the meaningful representation. So we have to parse out each error, the alibi witness, the selection of jurors you mentioned, the failure to object to relevant testimony, insufficiency, ineffective for not arguing a lesser sentence, a number of those things. That's the strength of each individual one, and then we have to break them down to see whether or not we agree with you or not. Is it egregious enough, or were they rhetorical comments? Were they fair comment? I mean, that's what makes this brief kind of, I have to admit, I mean, it makes it a little more difficult than most, because it's really not just one error in and of itself that's going to carry the day for you. It's going to be the cumulative aspect of it.
Well, correct. It's certainly the cumulative, but I would submit that this case rested on the testimony of the alibi. All those eggs were in that basket with the alibi witnesses, and yet the prosecutor told the jury that the alibi witnesses viewed police reports. As an officer of the state, he told the jury that they viewed police reports when there was no evidence, there wasn't even a question asked of them, whether they viewed police reports. And that's highly improper. That's testimony. It's highly prejudicial. Then he went one step further and said they fabricated their testimony to compensate for what they viewed in those police reports. That's
kind of somewhat, I think, supported by the argument regarding the hearing out of 440 of the witness recanting her testimony and what she was told by the officers, what she saw, and that's a different
witness.
It's a different,
different charge.
Yeah.
But
she's the one that ties him into the individual, the only one that ties him in
to the assault
arson.
second. Or I'm sorry, the arson second.
Yeah,
Yes,
arson second.
yes. The arson first was with the alibi witnesses. They went to that charge. But then further, after he told them they fabricated their testimony, again, that is in light of all of the other inflammatory information that came out during summation. And we know, and then went further and never requested an alibi instruction to the jury, and never requested a curative instruction to tell the jury that they should not consider the prosecutor's testimony.
Well, the people conceded that, though, right? I believe that people conceded the alibi, or no?
I'm sorry, they conceded that he shouldn't have done that.
No, I know.
I'm
I'm just saying, I mean, is it whether or not when we weigh it, obviously.
Yes, no, definitely. I think those alone would render the trial unfair. And then you add the firefighters.
The problem I have with the firefighters, quite frankly, is the record doesn't appear to be, I don't know if there was 2 in there, if there was 50 in there. Were they in the front row? Were they in the back row? Were they observant? Were they not observant? And it appears to be mentioned just once in the record.
Well, it's mentioned twice. It's mentioned the first day, there's 2 days,
Yes.
right, of trial, and he mentions it when he brings it up to the judge. But then he also mentions it during summation, and he notes them sitting in the, obviously, I'm assuming they're visible to the jury because
Let me
he
ask you
feels
something.
compelled
Would
to
your
ask them
argument-
about it.
Would your argument be the same if there was 2 firefighters sitting there?
They were 2 firefighters. Oh, 2 as opposed to 10?
Yeah, 10.
Absolutely, because, well, no,
Yeah, that's what I'm saying. We've had cases like this. It's
Yeah.
not our first rodeo.
Right.
I mean, but we normally had the number of people that are in the court.
Right.
If we only have 2 here as opposed to 10 or 15, I think we have a different argument.
well, I think the problem with this case is that the judge, once there is a state actor, once the jury, the fairness of the room is called into question, the judge has an obligation to do something, even recognize that they're there. There's some discretion that needs to be exercised, because, and here they're not serving any
Why can't we
state
just
purpose.
assume there's just 2 there and it wasn't enough to, why address it? That's what you're losing me on the argument. I think if there was some information that is how many were there and how many days they were there, how they were dressed.
Well-
I mean, there's more of a record. I think more of a record could have been made here.
Well, I don't think there were a lot of police officers in Holbrook where the U.S. Supreme Court addressed the fact that you had security officers sitting behind the defendant. I don't know that it's the number.
That's a little different. Police up behind.
It's a little different.
In this situation, we don't have a fire person that's a victim.
We have critical testimony that's put on by firefighters. We also have investigator
Yes.
Dorr.
Was that my question? My question was there
Was there a
victim?
firefighter victim? Yes, but I don't think you need a
No,
victim.
I recognize, but those are factors that we take into consideration as to what pressure or what type of, like if they're coming here and there's 10 people sitting behind you now with all T-shirts on with a picture of the victim on it, there'd be an issue you'd have here. You'd make a
For
record
arson
of it.
charges,
Yeah.
with several,
Why don't you
investigators.
Why don't you address your 44010 motion?
Okay, so the 440 motion with Heather Brown. Heather Brown, first of all, there's no forensic evidence that connects Mr. Grant to any of the crimes. This is completely an eyewitness case. And the only testimony that connects Mr. Brown at all to the arson second charge is Ms. Brown's testimony. And her testimony is problematic at trial. I think, there were 2 charges that were dismissed. She just said things like, well, I asked him about that, and, he just looked at me was one, or he just said, oh, because, when I asked him why he didn't hung up the phone. So she's got problematic testimony at trial. And she admitted at trial that she was there on a material witness order. She was afraid she'd be put in jail. She didn't want to be there.
But the crux of your argument is that there was police threats and coercion regarding her children or child, that if she didn't testify favorably, and you, in your position, is you're entitled to a hearing, at least to develop that issue.
Absolutely.
Because the people didn't put any affidavit in from a police officers that were there that they didn't have this conversation. There's nothing in there other than your allegations, and it's just with an affidavit from the witness.
That are consistent with what she testified to at trial. Yes.
I think we have that argument.
Okay, and then finally regarding sentencing, and I hope we don't get there because we don't have to get there if we're successful on either of the other 2 arguments, is the sentence of 50 to life. And I would just admit that that's way too excessive given the facts of this case, especially in regard to the arson second charge that was tantamount to a singed rug and maybe some singe on the floor beneath it. He gets a consecutive sentence of 25 to life on that, and that's just, I would submit over the top.
Thank you.
Thank you.
Good morning. Well, there arguably could be some reasons to try to explain some of the conduct by both the prosecutor and the defense counsel. I'm not here to defend either party's actions or inactions. I'd like to focus on the issue of fair trial. And not surprisingly, I'd ask the court to look big picture on this. And I do think it's significant is that he was really convicted of arson first and arson second only. And I know what his defense was. Everybody who's read this transcript knows what the defense was. He had witnesses who served to explain why he was at the location at the time and place where eyewitnesses placed him at. So we know the theory of the defense. They even went so far as to accuse the individual who lived on the other side of the building as being the one who started the fire because of his drug involvement. So there was a theory of the defense that was pursued throughout the trial. 3 witnesses were called. So I submit to you that the conduct of the defense counsel is not tantamount to ineffective assistance. I don't believe the defendant was prejudiced by the conduct complained of in defense counsel's brief. Looking at the prosecutor's conduct, I'm asking the court to pull back and put big picture. If you've got a jury who looks through all these separate individual arsons, convicts on some, convicts on one, another charge isn't even submitted to the jury, I don't think you can say that the conduct of the prosecutor caused the jury to be prejudiced against the defendant. I just don't see how you can find record support when they're able to parse out the evidence in the way they did. So for that reason, I don't believe that notwithstanding the inaction or actions on either party, that we can show the defendant was deprived of a fair trial. With regard to the firefighters, I think what's significant here is that the fact there was arson was never in dispute. So the fact that they were there, I don't think was persuasive on this jury. As Justice Centris spoke, this is not a situation where there's a firefighter injured, anything along those lines. There were arson trials, yes, and they were significant, and firefighters were significant witnesses, but that was not what the issue in dispute was. The issue in dispute was the identification of the arsonist, not the fact that the fires were started. With regard to the 440 motion, I'm going to rely on the brief that was submitted by the people. I would note that there is a significant reliance on the fact that the inherent unreliability of a recanting witness. This was a very on-again, off-again relationship between the witness and the defendant. And for that reason and the other reasons set forth in the brief, we take the position that summary denial was warranted. Absent any questions, I'll rely on the brief.
Thank you, Counsel. 325, People v. Petrangelo. Morning again.
Yes, Your Honor, may it please the court. At the beginning, I want to point out on page 18 of our brief, the last line should read .2 supra, not .3, because we were in .3, I'm sorry. This is an appeal from a conviction for the crime of assault in the second degree following a guilty plea. First issue I'd like to discuss concerns the waiver of appeal. I don't think the trial court's explanation was accurate when he said that there was no further review of anything and there was no written waiver. So we submit that the court can review the issues that the defendant, the appellant raises. The state police in this case basically arrested the defendant at his house, searched his car, which Judge Miller then suppressed, or anything that came out of the car. But an hour after they arrested him, they gave him his Miranda warnings. There was a statement made on the way to the police station that we submit should not have been allowed.
Wasn't that statement, that's where I dropped the victim
Dropped her off, yeah.
And he's not denying that he did that. He just says it, and then I drove away. I didn't back into her. So I don't understand what that statement means.
I don't know if it was a backup or a break, to break her arm somehow. 2 broken arm cases today. That's unusual.
But he doesn't deny that he was there.
No,
a statement on the police.
No. I think it just shows. It gets into the second issue of the state police conduct about how they sort of badgered him into getting his phone, turning over his phone, and then to gild the lily, had them sign a blank form, and then, which they filled in later, and we submit that is improper. And I think that before they offered it back, they had enough time to go through the phone to look at what they were seeing. So that conduct, and insofar as the guilty plea is
But
concerned.
if the appeal waiver stands, we can't reach whether the court should have suppressed the phone. Isn't that correct?
Yes. And we submit that there was an improper waiver.
I just have a question about probation. I looked at the sentencing, I looked at the documents that come out of the sentencing. There doesn't seem to be any mention of 5 years of probation. I know it was part of the plea negotiations beforehand, and it seems people are agreeing to that, but I don't see the court saying as part of the sentence, I sentence you to, and it's not in the commitment documents. Are you conceding that the court said, I'm sentencing you to 5 years probation, and that's why it's not being raised?
That was the plea bargain. Yes, because he,
I get, Counselor, not to catch you off guard, because it was a plea bargain. The point being is that the sentencing minutes does not reflect any mention of the term of probation.
right.
But the commitment does, but the sentencing minutes don't. So the question becomes
I'm
whether or
sure
not
he
that-
signed, I'm sure he signed conditions of probation, but
Yeah, but once again, if the court doesn't articulate its terms of probation, we don't know if it's a 4-year or 5-year, because it could be, doesn't have to, they changed, it doesn't have to be 5 years anymore.
we can figure that out and advise. the
We will,
court.
we'll figure that out, we'll take care of that.
Okay, thank you. Other than that, we'll rely on the
Thank you.
brief and not so much of the record.
Good morning.
Good morning, may it please the court. This is one of the better plea waiver colloquies that I've seen. They don't have to be in writing. This was verbal. The plea colloquy was segregated from the waiver of appeal colloquy. They were highlighted as being two different things by the court. And the minutes of the plea colloquy and the waiver of appeal indicate that both waivers were done knowingly, voluntarily, by the defendant. The fact that he experienced some buyer's remorse after the fact really doesn't adversely impact on the voluntariness of the plea. And it's not surprising that he would experience some buyer's remorse after he had managed to convince the victim yet again that she needed to forgive him. So that doesn't change the fact that his pleas and his both of his waivers were knowing and voluntarily entered. With regard to, he wasn't really arrested in his house, although it is his house, but it's his parents' house. And that's kind of important because his parents invited the police into the house. So we're not really dealing with a patent violation here either, by the way. The police were invited in. They did tell him that they would likely arrest him if he didn't come voluntarily. He came with them, but he was in custody. We all agree he was in custody, which is why he was given Miranda warnings when he got to the station. The police didn't question him in the car. His extemporaneous statement, oh, that's where I dropped her off, it's not really a statement against penal interest. It's simply an observation on his part, but it wasn't responsive to any questioning by the police. So there's nothing wrong with that. As far as the car search goes, the officer who testified at the suppression hearing couldn't even remember if he saw anything of note in the car. He just did a cursory look in the car. So that's not really an issue here. It was suppressed, and we don't have a problem with that. The police didn't badger him. Oh, the police so didn't badger him.
They did make multiple requests that he turn the phone over.
Well, not exactly. If you take a look at the 2-hour video of the interaction with the police, he throws the phone at them saying, here, go ahead and search it. And then they come back in with the written consent form saying, we just want to make sure you understand what you've just consented to and that you don't have to consent to it. They go through the form and then they read through he signs it. They tell him, this is a consent for us to search your phone. He signs it. I'm giving you, this is the second time he gives them consent to search the phone. Then they fill in the pedigree information, if you will, and they read the whole thing over to him. And he's like, oh, well, now he starts sort of hedging a little bit. It's really important to look at what's going on the video. And then they're like, if you're not comfortable with this, take it back. It's all good, take it back. No, and he slides the form back in front of, that's another consent. I mean, he's consented multiple times.
So if we find that he consented, then we don't need to address the suppression. But what about the sentence?
All right, I have to confess, I didn't review the sentencing minutes before coming here. I probably should have. If indeed the court didn't articulate 5 years, he didn't articulate the term of probation, I think maybe you have to send it back so the court can do that. I know that seems like an odd thing to be admitting to.
But obviously recognize we can't turn a blind eye to it. So.
Right, it's clearly that's what everybody meant to have happen. That's what it's reflected.
It was negotiated beforehand. The judge even mentioned it, perhaps earlier in the proceeding, but at the time of rendering sentence, it's not mentioned.
Right.
And it's not even in the documents that I see committing him.
Yeah, and I think that was simply an oversight. And it's an oversight that's easily corrected, albeit one that has to be corrected by actually getting the defendant back in and having the court pronounce the sentence. So respectfully, and the waiver of appeal, I just would point out, doesn't adversely impact on the concession that I just made regarding that, because the court still has an obligation to pronounce sentence. So even though I think the waiver of appeal is perfectly good.
Thank you.
Thank you.
326. Gustafson.
Good morning, Your Honors. May it please the court. Marco Sircone appearing on behalf of the Gustafson defendants. I learned late yesterday that the appellant's attorney was not going to make it today. So I intend to be very brief. I just want to address one point that was brought up by the appellants in their reply brief, which I would like to clarify for the court. The trial court got this right in that the acceleration by the successor company by Bank of America was a successor by merger to the mortgage holder, which was BAC Home Loans. They accelerated the debt with a notice of intent. If you look at page 19 of the record where the acceleration letter is included, it specifically says if you don't cure your default by March 19th, the mortgage payments will be accelerated and become due and owing.
Counsel, let me ask you this question.
Yes, Your Honor.
It appears on June 12th, 15, that the mortgage was assigned to Bank of America. Is that correct?
On June 12th of 15?
Yeah, that's my notes.
No, in June 12th of 15, I believe it was assigned to Wilmington. Bank of America. Premium.
Yeah, but it goes to assigned to Bank of America, successor, Mercer to BAC to Pertrium Mortgage, so and so.
Correct. This was assigned and reassigned several times. It gave me a headache trying to figure it out.
Your point is this, as I understand. Your point is the acceleration was valid, therefore the statute of limitations ran.
Exactly.
And your point is it's valid for two reasons. One is that prior action was an acceleration.
Correct.
Okay, but the problem with that is the prior action was dismissed for lack of standing.
That's not the problem, Judge, if I could be heard on it. Because if you look at page 24 of the record, which was Judge Chimes's decision to the initial motion on standing, she specifically says on that page 24 of the record that I find that BAC Home Loans, which was the predecessor to Bank of America, is in possession of the mortgage. They are not in possession of the note, countrywide.
Okay, but hold on.
Yes.
Hold on. Then the mortgage is academic for acceleration.
Judge, I respectfully disagree
Well,
there.
there's all kinds of case law on that the note is the significant.
But if you look at page 54 of the record, which is the provisions in the mortgage, that specifically says it gives the lender the right under the mortgage to accelerate it. It makes no mention of the note.
So let's get back to your point then.
Correct.
Okay, go ahead.
My point is that Bank of America, when they became the successor by merger to BAC Home Loans, that they were bound by what BAC Home Loans did because they were the successor company by merger, and because BAC Home Loans accelerated the note back in 2011, that the statute of limitations passed by the time that the current holder of the mortgage foreclosed in 2015.
Okay, so your point is that that the fact that, that the standing issue where the court probably went one step further, they didn't say you failed to produce. They said you're not a holder of the
Correct,
assignment.
because under the case law in New
So
York.
if they weren't a holder, how could they be the holder at the time of the acceleration, which was prior there?
They were the holder of the mortgage. They were not the holder of the note at the time of the acceleration. That's a distinction with a difference.
Okay. And is that what he said, though?
That's exactly what Judge Chimes said in her decision.
I don't
BAC, that's page 24 of the record.
Yeah.
It's a copy of the transcript of her decision. It specifically says, if you'd like, I can read from it. It
Yeah,
says.
I'll take a look at it. I
Yeah,
know
it
what you're talking about.
specifically
There's a
says,
short-
I find though plaintiff BAC Home Loans was assigned the subject mortgage prior to the commencement of this action, the note is held by Countrywide. And in order to have standing to foreclose, you have to be the holder of the mortgage and the note. It's a distinction with a difference.
Yeah, I
submit to the
thought
court.
there's case law that says that the key instrument is the note. But why don't you do this for us?
Yes.
Not that we want to continue to have you read, but I don't know where my record is. The page before that is the order, right?
Correct, the order that was
Right.
signed by the judge, correct,
Okay,
23.
So what does that say?
In the mortgage.
You don't have to read the first sentence or two that talks, it sort of throws case law in there, right?
Do you
Unless it's
want?
relevant.
It says
The
ordered
decree,
that in
don't
a mortgage foreclosure action, a plaintiff has legal standing to commence such action only where it's the holder or assignee of the mortgage instrument and the underlying note and mortgage
Okay, so that
So
says
that-
you gotta have both.
to foreclose.
And then what does it say?
Since plaintiff Bank of America was not the holder or assignee of the mortgage instrument nor the holder or owner of the mortgage note at the time of
Okay.
the attempted.
So my point is this, is that seems to me to go much further than just dealing with standing, although that's the ultimate conclusion. It didn't say you failed to produce it, and therefore you don't have standing. It made a judicial determination that they were not the holder of the note or mortgage. So if they weren't the holder of the note and mortgage at the time of the commencement of the action, how could they have been the holder and of the note and mortgage at the time of the acceleration back in
I
February?
would submit to you, Your Honor, that
2010.
must have been a Scrivener's error in the order.
But nobody appealed it, did it? Did they?
The bank did not appeal it, no.
Yeah.
No, but
Okay.
but there's an inconsistency with the transcript that's attached to the order. That transcript is attached to
But
the
you
order.
recognize that that might be a hurdle for you. But your point is really what the essence of the decision was that this distinction between mortgage and note. And so your point is that the acceleration back in February of 2010 was valid.
Correct, because an
And-
acceleration is not a foreclosure. They're two different, there's a
No, we
standard to
recognize that.
foreclose, and then
Yeah.
there's a standard to accelerate, and I
I'm
believe.
just going to ask you one more question.
Sure,
because
happy to.
The other question is you started with the idea that this was an effective acceleration, okay? If it's an effective acceleration, it sort of is a threaten that they're going to accelerate it, and it's not the whole amount. The mortgage, just for the sake of our discussion, is over $200,000, right? And it seems to me that all they're asking for is, look, you better pay whatever was due, $47,000 or $50,000, and if you don't, then we're going to, if you don't pay by March of that year, and again, I don't have it in front of me, then what they were going to do was accelerate it. So it's almost like a threat to accelerate. Tell us why that's.
I'll tell you why, because I think it's a misinterpretation by the plaintiff's attorneys in this case, because if you clearly look at the acceleration letter on page 19, and I'm quoting, if you don't cure by March 19th, your default by March 19th, 2010, the mortgage payments will be accelerated and become due.
Okay, so your point is that when that date passed, it was an acceleration?
Exactly.
Okay.
Exactly. If the court doesn't have any other questions, I'll rely on the rest of my papers. Thank you.
328 Jones v. 2630 Attica Road. 328 James v. 26030 Attica Road, Inc.
Thank you.
Morning, Your Honors. May it please the Court.
Justice Carney recused.
Thank you, Judge. Anthony Rupp on behalf of Brown Chiari. Your Honors, I'm new to this case, as you know from the sign-in sheet this morning, and as I was reviewing the brief and the records, I think similar to the way you would, one particular fact jumped out at me, and that is that Mr. Capizzi, the attorney who handled this file and was the only attorney who handled it at Brown Chiari, claims that over 33 months he spent, in his estimation, a grand total of 20 hours on the case. And that's after doing 4 to 5 depositions with preparation, all the pleadings, the summons complaint, all the discovery, all the court appearances, all the client meetings, the site inspection, the other investigation, the negotiations to resolve a lien issue, case strategy and planning, medical records and summarizing them, expert witnesses and trial preparation, including trial subpoenas. With all of that backdrop, Mr. Capizzi claims that he spent roughly 10% of the time on the case at the Brown Chiari firm and 90% of the time at his new firm, the Collins firm. I submit, Your Honors.
The court didn't believe him on that, though, did they?
Well, the court didn't, Judge. The court found that they didn't believe him quite, and they gave 25, 75. But this is not a case where we have 2 different firms. One firm handles it through...
This is an unusual, in the sense we have one lawyer, one client from start to finish.
That's exactly right, Judge.
That person is in possession of the information and provides an affidavit, and his former law firm had also their own information because it was their firm. They know what paralegals work, and they provided an affidavit for the court. And all that was before the court. You seem to be here arguing that you need discovery.
Judge, we believe that because of the nature of this case, this is not a situation where one firm had it and it did transfer to another firm, and we have 2 abilities, of the first firm to present its case. Mr. Capizzi is solely in possession of the knowledge as to exactly what he did.
And what words were used, which I someday would like to figure out, in his mind?
Well, Judge, yeah, that was interesting from my predecessor on the oral argument of the motion. But, Judge, I think it's apt here. Basically, we contend that Mr. Capizzi threw his former firm under the bus. It is impossible to spend 20 hours preparing a case all the way up to the threshold of trial. He was 1 month away from trying this case, which had been previously scheduled in September of the earlier year.
Which was handled by the same judge, correct?
That's right, Judge, but 20 hours to do 4 to 5 depositions and all of the things I just mentioned.
Can I ask you this question? That was before the lower court. The lower court knew what he had done and what he claimed he had done within 20 hours. And the court had before it what he did after the motions, motion limine, the trial, the verdict, the settlement of the case. It seems to me here that, in essence, and I know it ties into your second issue, is that it's impossible. There should have been if there was more work being done, then the split shouldn't have been 75-25. It should have been, 35, 65, 40, 60. I mean, really, what this boils down to is how the court apportioned the fees.
I understand that, Judge, and I understand that this court and this panel likes to have fee dispute cases here when we're talking about people who get 50 years to life, about as much as you want to, shovel your driveway. But let me just say, I think this is a case where fairness, fundamental fairness, requires that there be a hearing here. And the reason for that is Mr. Capizzi was uniquely in a situation to say what he did at each firm, and he chose to throw his former firm under the bus. It is incredible, I submit, as a matter of law, that he did everything in this case, including getting it to the threshold of trial and all those depositions, court appearances. He's going out to Wyoming County, and he spent 20 hours on the case total over 33 months. That
what
alone.
Standard do you want us to use to say that the judge was wrong? You're telling us he's wrong. Capizzi asked for 10. The judge gave 25.
But Judge,
and you want us to say, send it back down so you can get discovery. What standard do we use to say the judge was wrong? Judge,
it's an abuse of discretion standard under a fee dispute. But I believe that the record shows that this is a case where there should have been, and we're not asking for lengthy, Judge, we're asking for limited discovery and an expedited hearing so we can develop a full record. I will be honest. I would like to cross-examine Mr. Capizzi and ask him how he did a pleading, a summons, a site inspection, multiple appearances out in Wyoming County, 4 to 5 depositions, all of the pleadings, all of the bills of particulars, the medical records, the expert witnesses, the subpoenas, the prep for trial, and spent 20 hours on that over 33 months.
The court made the determination. It didn't need to hear more. It's been familiar with the case. It has the affidavits in front of it, and it says, this is enough for me to allocate the amount this way. And we have to decide, is that arbitrary and capricious?
And Judge, I understand that, but I believe that the judge did not have, what he saw was the parts where Mr. Capizzi appeared in front of him for a lengthy trial. What he disregarded, I believe, respectfully to Judge Griffin, I know Judge Griffin, I know him, I think he's a wonderful judge, but he did not see the 33 months of preparation that got this case to within...
Well, Counsel, we have to concede, I mean, time is not the total element, because you're literate, you've been around. It takes a long time sometimes to get a reply to interrogatories or doing deposition, but setting that issue aside, we understand your argument. What do you think the fee split should have been based upon what's before us?
Judge, I think that the case that was cited in Mr. Doyle's brief, I know it's not binding on this court. It was the Vallejo Builders case versus Family Youth Diocese of Brooklyn. It's not binding, but it was a really detailed example of an outgoing firm that took a case all the way, did 100% of the discovery, as Brown Chiari did here, did 100% of everything that had to be done in the case pre-trial, and got it right up to the verge of trial. We did more in this case to get this case trial ready and to bring it within 30 days of trial than the outgoing firm did in the Vallejo case. And in that